tool in order to tackle the problems arising in these types of markets, or whether we should be looking beyond into other alternatives such as regulation. I don't know how familiar you are with antitrust law, but I always like to start with, when facing such a broad question, with reminding my audience and myself what were the origins of antitrust. So, in order to do that, we have to take a time travel 120 something years back in history into the United States. And if we would be able to do that, we would be looking at an economy which is totally which main or key markets are controlled by trusts. And I'm referring to sugar, railroads, oil, and so on and so forth, right? Trusts were entities that operated in the market as if they were monopolies, as if it was only one entity. And they did that through a very complex scheme of agreements through which the shareholders of each of the single companies transferred their shares to the trustees. I don't know if you know what a trustee are, but certainly you remember or you recall very important names such as Rockefeller or Rothschild. These were the trustees of some of the most important trusts back then. Now, if you have a trust in a sector, it operates as a monopoly. And what monopolies usually do, it's not always like this, but this usually happens with lazy monopolies, which is the greatest fear that we antitrust lawyers have, is that normally prices increase, innovation decreases, and there is a reduction in the products and services range. And sometimes if we do have an oligopoly, there is market allocation, right? This is a win-win situation, both for the trust and for the shareholders. Trust is operating as a monopoly, so they are making monopoly rents, monopoly benefits, and the shareholders are getting the benefits of the aggregated company. So not just the company they are shareholders to, but the whole group of companies. So it's a win-win situation for them. Now, obviously, somebody has to be damaged in this situation. And normally, the ones that are damaged are the people with the less bargaining power, employees and consumers, but also the market structure. The market structure suffers from this kind of conduct. Now, the whole situation started generating a big debate in the North American society, and some of the legislators heard it. They listened to it, and one of the most important senators back then, which is the Sherman, one of the senators of Ohio, Mr. Sherman, was able to pass a law, which nowadays currently bears his name, which is the Sherman Act. The Sherman Act makes it possible for the federal government to detect, prohibit, and sanction these collusive agreements, but also makes it possible to break up the monopolies, right? Now, flash forward 100-something years later, we have a similar situation because we do also have digital titans in the economy. But I will argue that the problems that are posed by these titans is not the same as the ones that we had with very static and slow developing monopolies that we had in the past, in the 19th century, which, as I mentioned, was railroads, sugar, oil, right? So nowadays we have these digital titans. Now, to be honest, these undertakings have had a very beneficial impact in society. We've seen the innovation growing. We already know that there was no innovation in the markets, in the economy, in the sectors itself, but on how the sectors are operated. But what we have is an increase in efficiency. We reduced transaction costs, not so much information cost, or at least not in every aspect of the market. On the other hand, these titans have also posed a series of competition problems, and some of the conducts are at least suspicious from a competition perspective. As I told you, the problems are similar, but they are not exactly the same, as what we had in the 19th century. And I say that they are different because these undertakings, these current Titan undertakings, have different features. So we're talking about two or multi-sided markets and that are considered gatekeepers. We're talking about undertakings that operate in several markets at the same time. So take, for example, Facebook, which operates in several markets, and it operates in the advertisement market too. And they are obviously brokers, they are intermediaries, but they also operate in the upstream and downstream market. So what is called vertical integration, which generates a lot of incentives for discriminating the rest of the undertakings that do not belong to the network. There is a high reliance on big data, which increases efficiency, but also makes it possible for them to leverage this dominant position from one market to the rest of the market, and it increases the entry barriers in the market. They are very rapidly evolving, they grow very quickly, but they also expand to other markets very quickly, and the conducts are constantly changing. The type of conduct that they operate in the market are constantly changing. And they've also been characterized as winner-takes-all markets because there are cross-site network effects, very strong cross-site network effects. What are the tools that we have in order to tackle the problem? So in my opinion, we have three different types of tools. We have the traditional competition law approach, which is normally an ex-post control of the conduct. And basically, I'm referring to these collusive agreements, prohibition, and the abuse of dominance, which you can find in Articles 101 and 102 of the Treaty of Functioning of the European Union. They are already in place and they are being used, as we will see in a minute. We also have this so-called regulatory competition law, which is a tool that is enforced ex ante, and I'm basically referring to the merger control policy. It's already in place. We have some regulations dealing with the merger control, but it's only rarely used in order to prevent these mergers. And then, as a third option, we have regulation, which is also applied ex ante. I'm referring to general rules which all operators of the market need to comply with, and we only have some proposals in Europe. There are already some regulation acts in the United States, but in Europe we only have proposals. Now, what has been done in these markets? Now, we have a lot of proceedings currently open in Europe. I don't want to mention the ones in the United States because it's almost as we have one proceeding a day. But in Europe, we have proceedings against Google, Apple, Facebook, and Amazon from the European Commission and different national competition enforcers, right? We have the French, the British, the German enforcers working on digital platform cases. And then we have some proposals for regulation. In Europe, we have these new Digital Markets Act proposal. We have also the Digital Markets Unit as a proposal, and the German government has already amended the German antitrust regulation. It's the 10th Amendment, but it's dealing with digital markets and monopolies. In Europe, they've already enforced some, they've passed some regulations like the End Platform Monopolies Act, Platform Competition and Opportunity Act, and so on and so forth, right? This is what's been done for the moment. Now, I want to address what are the problems of or benefits of enforcing antitrust, traditional antitrust, regulatory antitrust, and regulation. Now, in order to enforce antitrust, the first one that we need is harm, a theory of harm. But we do need to know what is being harmed. And here we have two different approaches. We have the most popular one, which is the consumer welfare standard, that in my opinion is not well suited in order to tackle these problems with digital platforms, because it's not well fitted in order to detect exclusionary abuses, which is the biggest problem with competition platforms, right? In my opinion, we should be shifting to other approaches, such as the market structure approach, which I think it's better suited in order to detect exclusionary conduct, such as predatory pricing, as Professor Boix was mentioning the first day, which is what's happening with Amazon, right? Not making profits for a lot of years, and then suddenly when every competitor has been eradicated from the market, then there is a surge in the profits, right? So these type of conducts are not well detected or sufficiently easily detected with a consumer welfare standard, but we have other alternatives such as the market structure approach, which should be, in my opinion, used. Now, the problem with antitrust is that you always have an ex post intervention. So once the conduct has already been carried out and the damage has already been produced. Although theoretically, you can apply competition law with a potential damage, which is not very usually done by competition enforcers, but theoretically, at least you have this option. Now, if the aim is going back to normal, so going back to the original situation where competition was not damaged, competition law is not well suited in digital platforms, because once the damage is done, it's very difficult to go back to normal, especially if we're talking about big data. Once I've monopolized the market, once I've gotten all the data that I can get, it's very difficult to, and once all the competition has been eliminated, it's very difficult to go back to normal. So this ex post approach is very problematic in digital platforms, in these markets, right? And then we have other problems because competition law is treated as criminal law, at least from a procedural perspective, in order to comply with all the procedural and substantive guarantees of the undertakings that are being investigated. That means that we have very long and very heavy proceedings where we have a standard of proof super high, almost similar to the ones that we have in criminal proceedings. These make, as I told you, very long proceedings, and we have rapidly evolving markets. So once the proceeding has been finished, once we've sanctioned the undertaking, the conduct has already changed and the market has already changed. So it's not useful in my opinion. We have a second tool, as I was telling you, which is the regulatory antitrust. And here I want to talk a bit about mergers and acquisitions and what we call killer acquisitions. Now, it's super important if you're talking about markets, at least in my opinion, to have competitors, right? You need competitors in order to maintain prices low, in order to boost innovation, and so on and so forth. So removing competitors from the market through mergers, it's problematic from a market structure perspective, right? So what does competition do? As I told you, it decreases prices, it boosts innovation depending on the market, and this is what both actual and potential competitors do. But if we have very high entry barriers and we've eliminated every competitor possible, it's very difficult that we have low prices and innovation in the market. Now, not every competitor has the same impact in this boosting of innovation and maintaining prices low. We have both strong and weak competitors, depending on the size of the competitor and on the tools of the competitor. And enforcers, competition enforcers, at least in Europe, are very reluctant to stop mergers if we are not able to prove that the competitors are at least potential strong competitors. Now, what happens in digital platforms or technological markets? That what we have mostly are small startups, which at first sight might not be very powerful, and therefore it's easy to absorb them, right? From a competition enforcer perspective, they are weak competitors and they do not offer all the benefits that a strong competitor could offer the market. So they are able to the strong competitors, the strong players are able to easily absorb them through a merger, and mostly they also fall under the radar of competition authorities. This is a problematic situation, but there is even a greater problem, which is the killer acquisitions. Killer acquisitions, or the problems of killer acquisitions, have been proven in pharmaceutical markets. What happened with a killer acquisition? A killer acquisition is an acquisition that's been done from a very strong competitor. They absorb a very weak competitor, which is developing a new technology, right? So there's innovation, at least in an embryonic phase. Now, the small competitor is absorbed by the big competitor. We don't have two players anymore. And what the big player does is eliminating this line of research of innovation, because innovation is costly. It needs a lot of money involved. So if you are a monopolist, you don't need to invest money in innovation because you've already absorbed your national competitor. Okay, so this is a very problematic situation that it's been proven in pharmaceutical markets, but in my opinion, it can be easily translated to digital platforms, right? So we have to be careful with mergers and acquisitions in digital markets. And finally, we have this third tool, which is regulation. In Europe, we are still at a very initial phase. There are only proposals, as I told you, for example, the DMA, which is the last proposal that the European Commission has done, and we're still analyzing that. Competition scholars are very reluctant to introduce regulation tool because they say that it's very easy to capture or to lobby the enforcer, which I think from a competition law perspective that it makes no sense. The European Commission, it's a very big enforcer. The European Parliament, it's a very big entity, and it's, in my opinion, very difficult to make an impact to lobby the European Parliament. The second risk that they argue in order to avoid the enforcement of regulation is that regulation usually hinders innovation. And we're super into innovation from a competition law perspective. Actually, what they say is that we are adopting an innovation approach, not a market structure approach, nor a consumer welfare approach, but an innovation approach. Now, if this is true, which I'm not arguing that it's not true, I want to ask myself, or I want to ask my audience, what is the kind of innovation that we want? We don't want innovation at all costs. Innovation has to be regulated, and the problems happening around innovation need to be controlled. Now, we can go in two ways here. We can go heavy-handed with regulation, or we can go light-handed with the regulation. What the DMA is, in my opinion, is a very light-handed regulation. They suggest that all firms have access to essential facilities in what's considered an essential facility in a digital market. For example, infrastructure or data, big data, should be considered as an essential facility in order to avoid this phenomenon of too small to succeed in the market. If I do have access to essential facilities in exchange of a compensation, I'm not arguing that they should have access for free. In exchange for a compensation, they have at least the opportunity to succeed in the market and become a strong competitor. And we've already seen the benefits of competition. It also prevents this problem of leveraging this dominant position that firms or undertakings have in one market to other markets, avoiding dominance position, this extension of dominant position. And we also make sure that undertakings are succeeding because of their better performance, not just because they have more data than the rest. This DMA also suggests the possibility of forcing standardization and interconnection, which also makes it easy for competitors to participate in the market and attract consumers. Now, they're not saying anything about the prohibition of vertical integration. As I told you, it's a very It's a great problem in the digital platforms work because they participate not just in the platform market, but also in upstream and downstream markets. Take Amazon as an example. Amazon is the market, but it's also a seller competing with the rest of the sellers in the Amazon platform, and it's already being sanctioned for the discriminatory practices that it introduces, benefiting Amazon as a seller itself and in detriment of its competitors. This is something, this prohibition of vertical integration is something that we've already have in different markets. I mean, it's not an illusion. It's not something that it's impossible to be done. We have this in the electricity market. And I think it's something that needs to be at least analyzed from a competition perspective. Now, what are the advantages of regulation? And I'm not biased here because I'm a competition lawyer. I mean, but I think that regulation is a good tool here. What are the advantages? The problem is that incumbent platforms do not always have a dominant position in the market. Proving dominant positions in the market is super complex. It's almost impossible. And we don't always have a clear dominant position in the market. So it's always easy to go through regulation tools and not through antitrust tools. It's true that some competition enforcers have the possibility to sanction economic dependence, which is a relative dominant position, but not all the enforcers across Europe have this tool. And as I told you, the proof of dominance is super complex from an economic perspective. And there is a second advantage, which I think is the most important one, that we have to acknowledge that there is not always a harm in the sense of prices to consumers, right? We've already been talking about predatory prices. If you take this as an example, you see that at least in the first phase of the conduct, consumers are super benefited because the prices are super low. What's harmed, what's damaged is the market structure. We are damaging the competitors, right? This is the idea. So sometimes this consumer welfare standard is not well suited in order to deal with this type of practices. Competition law does not deal with democracy. It has nothing to do with human rights, nothing to do with privacy, among other goods that should be protected in these digital platforms. There are some scholars that are arguing that competition law should cope with these goods also, but in my opinion, this is just an introduction of a distortion of the competition tool, which should only deal with efficiency and market structure. This over-encompassing of goods protection under the competition umbrella makes no sense from the legal certainty perspective, right? So now, to finish my presentation, I wanted to just elaborate on some conclusions. I think that the best tool in order to address these practices is a combination of the three tools that we've analyzed here. Competition law needs to be applied. Of course, this ex post control needs to be applied. However, it should not be the main line of defense against the anti-competitive practices in these markets because of all the problems that we've already seen. I think that the most important tool that we have here is the regulatory antitrust. We need to control how dominant positions are acquired. It's a good symptom that you have a dominant position in the market if this dominance has been acquired through efficient conduct. But if you acquired a dominant position through an M&A, then it's starting to be complicated. It's better to prevent the problem from arising than tackling the problem once we've already have this in the market. And we have to balance the measures, especially if we're talking about regulation, because we want innovation happening in the market. So we need regulation, but not a very heavy-handed regulation that might hinder innovation. And these were just my conclusions, and I'm happy to get questions or comments.
So many thanks for this wonderful intervention. because we have a complete and in-depth review of all competition law issues here. I guess we will have some questions. I don't know if here or online. Online we have a comment, but it's only a thank you. So if not, and for the moment, I would like to ask you about the public debate, because regarding the legal issues, I think that the explanation was so good that you have covered everything. But regarding public debate, I am not a specialist on this field, but the information I have is that in Europe, there's almost no debate. The European Parliament has said something, but that's not an important issue. But in the US, they have already some parliamentary commissions. They have debated that extensively. And the interesting thing is that Democrats and Republicans are aligned, not depending on partisan lines, but because other things. And you can find Democrats who are really critic with those digital platforms and the current regulation. And you have also Republicans who are really concerned about the situation. And you can also find more establishment or institutional Republicans and Democrats that say, well, that's not so problematic at all, because those companies are innovative, they are thriving, the US economy is thriving because of them. But in Europe, we don't see that. We don't see a debate, or at least that's the image I have. I don't know if that's true. Is there a debate in Europe? And if it is, which are the lines that divide positions?
I think there is a debate in Europe, but it's not widely spread. You know, there's a debate among competition scholars, among administrative lawyers, but we don't have a debate in the society as such. I think it's a very complex topic, and I don't know how well informed are people and how close they feel to the problem. If you think about platforms, you mostly think about privacy issues. If we're talking about Facebook, which is something that we competition lawyers don't talk about, it's not our thing. If you think about Amazon, then you think about predatory pricing. But since in Europe, predatory pricing, it's not a problem, it's not a big problem, because as I told you, we've adopted a consumer welfare approach, then we don't see a competition problem there yet. I think it's being discussed, but not very, I mean, not when you go with your friends, right? So this is maybe a bias that you have, but I've seen a lot of conferences, a lot of seminars that they are currently discussing about, for example, this DMA proposal, the proposal for a regulation. So I don't know. This is my opinion, my feeling.
So we have two questions here, Gabriel Domenic and then Mireia Artigot. Yes?
Yeah. And you said that we need regulation, but what kind of regulatory measures you're thinking about? For instance, how could we tackle the issue of killer acquisition? So how could you prevent this problem? Or
when I was researching on killer acquisitions, I noticed that the problem was that most of them fell under radar, right? Because we need certain thresholds to get certain thresholds in order for the undertakings to have the obligation to notify to the European Commission that they want to acquire or that they want to merge. The problem with killer acquisitions is that normally we absorb firms that are very small, they are startups, so they don't reach these thresholds. Now, my suggestion is, well, I have several suggestions here. I don't know how good they are, but for example, lowering the thresholds or an obligation to notify every merger and acquisition that's being done by the dominant firm in the market. It doesn't matter whether you're absorbing a big firm or a small firm, you have the obligation to notify. And a third suggestion of mine is the obligation to inverse this burden of proof. So So in my opinion, what should be done is that undertakings should be obligated to justify the pro-competitive consequences of the merger that they are suggesting. So with these three measures, I think that we can tackle more or less the problem. The problem won't be solved completely, of course, but there are some things that we can do in order to improve, at least make it easy, the detection, and work on the pro and anti-competitive consequences of this merger. I don't know if this answered to your question.
Many thanks. Mireia?
Hi, thank you very much. Thank you very much for the incredibly enlightening presentation. And I have a question and a comment or an idea. The question is due to my ignorance, which is this merger regulation that you talk about, it's applicable generally already to all types of takeovers or mergers, regardless of their digital nature, right? Like that is one thing. And the second one is well, no, actually that's the second question. You mentioned we need to regulate innovation, but how do you do that? Because exactly the fact of innovation is that you don't know that it's going to happen and how it's going to happen. And then ultimately related to this is, and related to Andres' question, I wonder if part of the approach of Europe is because we are de facto regulating the effects and consequences of American companies. Like we're not tackling our own let's say big techs because we don't have them. So our view on the market is very different because we are dealing with foreign suppliers that in fact we have a huge amount of problems even to get taxes on. So in that respect, our view, I think it's very different from the debate that they have in the US, where they have these market participants, let's say de facto, because they have the headquarters there, and at the same time with huge implications on actually their suppliers as such, no? And I would like to hear your view on that, and thank you.
Thank you very much for your comment. If I said that you have to regulate innovation, I was wrong, because you don't regulate innovation. What you regulate is how you use innovation. For example, what you can do is to force innovators to share their innovation with the others, right? So we have this thing, and it's already a thing in competition law. What we have is we sanction these refusals to supply, right? And it happens, for example, with innovation, with IP rights, with intellectual property rights, and so on and so forth. So what you can do is you can force those owners of IP rights or whatever they are doing, their trade secret, whatever, to share their innovation with others. Not for free, as I told you. They get a compensation in exchange, but they do have to share. For example, they need to share big data with third parties. And it's something that it's already being done with IP rights. There are seminal cases in the European Court of Justice where the European Commission and afterwards Court of Justice forces intellectual property owners to share these innovative thing with third parties. So my suggestion is to do this with infrastructure, with essential facilities in digital markets, which are infrastructure, digital infrastructure, the platform itself, and big data. This is my suggestion.
Many thanks. I don't know if we have another question. Yes, the last one, and then we move on.
Thank you so much for your very interesting presentation. I had two questions just on what you just said now. Isn't that already possible to do at the level of commitments imposed by the European Commission ex ante at when the undertakings notify a merger?
Yeah, so I'm answering to this question. Once you notify, you first have to be obliged to notify the merger, and you are only obliged once you reach the threshold, which is the problem here, because you're mostly absorbing startup companies that don't have a very high turnover, and therefore they fall under the radar. But once you notify these, once you notify the intended merger, you can reach a commitment with the Commission, and I don't know what can be the agreement, for example, sharing things, right? But this has not been done until now. Okay, so these essential facilities sharing is not a commitment that has been up until today adopted by the Commission, but you can theoretically do that.
And then what about, you talked about revising the thresholds for notification of mergers. What about instead of just relying on turnover or market shares, introducing data also? Data as a threshold for notification. For example, when Facebook acquired WhatsApp, it didn't enter the threshold. But if data was taken into account, they would probably have had more difficulties to merge.
Yes, the problem here, I think, with digital markets is, as I told you, that they play in different markets. So Facebook, for example, plays in one market, but it also plays in the advertisement market. And they didn't take into account this market. So first you want to make sure that you're choosing the analysis of the specific market that you're interested in. And then you have to make sure that you reach certain thresholds too. So I think we're getting better in analyzing what's the problematic market, but there are still problems because it's set in the regulation with the threshold. So my suggestion is more going into the threshold, because the other thing is something that the Commission needs to be used to analyze, right? So.
Thank you very much.